Hello, everybody. My name's Evan Farr, and I will be talking to you today about how to protect your assets from the expenses of probate and long-term care. For those of you who don't know me, let me tell you a little bit about myself, and you can see this on the screen in front of you. I'm one of about 570 certified elder law attorneys in the country. I've written 4 best-selling books in the field of elder law. I'm a top lawyer as rated by all of the legitimate rating agencies in the country, including locally with Washingtonian Magazine and Northern Virginia Magazine. Um, and I'm the creator of the Living Trust Plus asset protection system, which is used by about 40 to 50 attorneys around the country. And that's part of what we'll be talking about today. But let me tell you a little bit about my firm as well. Our firm has been around since 1991, helping protect folks like you. We serve all of Virginia, Maryland, and DC. We have offices throughout the area in Fairfax and Fredericksburg on the Virginia side, Rockville and Annapolis on the Maryland side, and also in DC. We have about 14 team members at any given time. And our firm does everything we're going to be talking about today, of course, and a lot more. Everything to do with elder law, estate planning, trust administration, probate, guardianship, special needs planning. One thing we don't do is contested litigation. Life's too short. We try not to get involved with anything where we know it's going to wind up being contested. We like working with happy families where people get along. All right, so getting right into the information. Actually, first of all, before we get into the information, if you do have any questions as I'm talking today, please use the Q&A tab on the bottom to ask those questions, and I'll get to those at the end of the webinar rather than interrupting during the middle. Excuse me. I will try to answer all the questions at the end. Sometimes people ask questions that are too fact specific or too complex to answer in the context of this type of webinar. But of course, we offer personal consultations, and you're, of course, welcome to make an appointment to have your specific or complex or fact specific questions answered. All right, so now we'll get into the material. When you think about long-term illness, what are some of your worst fears? Well, if you're like most of our clients, some of your fears revolve around winding up in a nursing home and running out of money. And those two things often go hand in hand because nursing homes are extremely expensive in this area of $14,000 to $16,000 a month. And many people who wind up in a nursing home do run out of money. But part of what you're going to be learning about today is that you don't have to be one of those statistics because there are a lot of things you can do to protect your assets so that you don't run out of money if you do wind up in a nursing home. We can't help on the medical side, unfortunately, with the memory loss. I know that's a big fear for a lot of people, but we do have a newsletter and a blog with lots of helpful articles about cutting edge medicines and new treatments that have come out over the years, and you might want to check that out. If you're not already receiving our newsletter, I encourage you to visit our website at farlawfirm.com and sign up for our newsletter. You can also get some of my books when you sign up. All right, a pop quiz. We said this is going to be about protecting your assets from probate and long-term care. So let's start with probate. What do you think probate looks like? Is it the happy gentleman on the left, where the older gentleman's telling the younger one, here's all you need? Or is it the maze of wandering people on the right where one guy up top is wondering, do I really want to jump into this maze? Well, of course, the correct answer is the maze. Probate is not just a maze, it is a nightmare. In fact, typically when you hear the word probate, it's in conjunction with the phrase, the nightmare of probate, because it really is an overly incredibly complex process involving court filings, starting with a qualification of an executor after probating a document, or it may not be an executor. We'll talk about that later. Um, Inventories have to be filed typically 4 months after probate is open, showing all the assets of an estate. And then we have the dreaded annual accounting, which has to be filed 12 months after the inventory. So we're now 16 months after the probate starting event. And then that accounting has to be filed every year as long as probate remains open. And there is no limit to how long probate can remain open. And these annual accountings are so complicated because they have to balance to the penny. It's an itemization of all the money coming into an estate and all the money going out during a 1 year period. And it has to balance to the penny. And people spend typically 40 to 60 hours going through to prepare these annual accountings. And often they get to the end and there's a discrepancy. Maybe it's only a 3 cent discrepancy because maybe somewhere among dozens of bank statements, perhaps many dozens of bank statements. Imagine you have 7 accounts in probate with 12 monthly statements. That's what 7 times 12 is 84. So that's 84 monthly statements with just 7 accounts. You've got to now go through all of those 84 monthly statements with a fine-tooth comb to figure out where was the 3 cent mistake. Maybe the bank's optical scanners misread an 8 as a 5 or a 5 as a 2. Um, Two of the most common mistakes that are still made despite optical scanning getting better and more sophisticated. So if you have to go through with a fine-tooth comb and spend another 40 to 60 to 80 hours to track down that 3 cent mistake, so be it. That's what you've got to do. Or the commissioner of accounts, part of the probate court, is going to kick the accounting back to you and say, fix it. All right. Probate is part of the court system. There's judicial oversight that goes along with this whole process. And because there's judicial oversight, it's very easy for people to contest something going on in probate, like filing a will contest, claiming that um, a will that's been admitted to probate was procured through undue influence, or the person who signed the will was incapacitated when they signed it, or being manipulated. Um, Very easy for anyone to come in and file a will contest. Probate's also expensive. General cost around the country is 5 to 8% of the estate. Imagine um, what's now in this DC metro area, kind of a normal estate of, let's just say, $1 million. Well, that's 50 to 80,000 dollars in probate fees and expenses. Part of that is taxes, part of that is filing fees. All of it is aggravating red tape, delay, and aggravation. The delay is it takes typically at least a year for probate to finish, and often, as I mentioned earlier, there may be no end in sight. There's no limit to how long probate can go on. And all of this is unnecessary because there are simple ways to avoid probate. But first, another pop quiz. When does probate occur? Is it during your lifetime, after your death, or both? During your life and after death? Think about it. The correct answer, the most correct answer is C. If you answered B after death, you're not wrong. And because most people, when they think about probate, they think about it after death. But the more correct answer is both. Now, your question is, why would you have probate during your life? And the simple answer is incapacity. If you become incapacitated while you're alive and you can no longer make legal and financial and medical decisions for yourself, and if you don't have the proper document in place or documents, which we're going to talk about in a moment, someone's going to have to go to court and have you declared incompetent to be and become appointed as your guardian and conservator, thus beginning the process of lifetime probate, requiring your guardian and conservator to file annual accountings for the rest of your life every single year. And that's why after or lifetime probate is often, usually even worse than after death probate. After death probate would typically only lasts about 2 years. It can go much longer. There's no limit, but lifetime probate is often something that goes on for 5 years to 40 years. I mean, depending how old someone is when they become incapacitated without the proper documents. Guardianship and conservatorship can be a very long-term thing with these incredibly complex accountings having to be filed every single year. The so this whole lifetime probate nightmare again is worse than usually worse than the nightmare of after death probate. The good news is that this whole lifetime probate, guardianship and conservatorship is a last resort process. This is not something you want to rely on. It's not something you want to ever have to do um, for a competent adult. Now, there are parents who have children with special needs, and when those children turn 18, we have to do a special type of guardianship and conservatorship called a coming of age guardianship. And that's unfortunately sometimes just a necessity, although not always a necessity, because some coming of age young adults are able to sign documents, which we're going to talk about in a minute, where they don't need guardianship and conservatorship. So even then, it's somewhat of a last resort. Um, but this whole process of guardianship and conservatorship requires notice be given to all the family members involved. It can be challenged. Somebody, if you're petitioning to be guardian and conservator, someone can come in and say, you're not qualified. You shouldn't be the guardian and conservator. Someone else should be. The person who is allegedly incapacitated may challenge it and say, I'm fine. I don't need someone making decisions for me. The court-appointed attorney, typically called a guardian ad litem, can challenge it, saying that they don't believe the person is incapacitated, or they don't believe the person seeking to be appointed is a proper person to be appointed. So there's all kinds of ways these can be challenged and make this whole process a nightmare. And again, once it's granted, that means annual accountings until the death of the ward. The person who is declared incapacitated is technically a ward of the state, and the guardian and conservator is basically appointed by the court to represent the state and report back to the estate every year on how the ward is doing and how their money is being spent. You don't want that. We don't want to ever have to go through this if we can avoid it. And there's an easy way to avoid this lifetime probate through what we call incapacity planning, or what we call in our firm level one planning, because it's the basic, most basic type of planning. This is all about signing specific documents that name someone to handle your legal and financial and medical affairs when you're not able to. And I'm sure a lot of you already have the most important legal document of all, which is the general power of attorney. If you don't, you need one, because this is what avoids the conservatorship. It avoids that whole living probate filing of annual accountings, because you're naming somebody to handle your legal and financial affairs if you become incapacitated. But it's not good enough to run out to Staples or Office Depot or go online to LegalZoom or Rocket Liar, and I may have mispronounced those a little bit, um, and download or use one of these off-the-shelf forms for a power of attorney, or Susie Orman. I think that's still a thing. She sells forms. The I was very saddened to see AARP recommending, one of their sponsors is Trust and Will, which is an online form factory. The problem with all of these online form factories is they're not attorneys. They don't know your specific needs and wishes. And they certainly don't know that you want a power of attorney that has asset protection powers. And the reality is 90% of power of attorney documents out there do not have asset protection powers, which I think, as an elder law attorney who does asset protection every day, are critical. I think your power of attorney needs to have the ability for your spouse or your children to do Medicaid planning, including the ability to do unlimited gifting, which is often needed as part of asset protection powers, and the ability to create and fund all types of trusts, both revocable and irrevocable trusts, even irrevocable trusts that aren't technically for your benefit, which is the main type of asset protection trust that we'll be talking about today, and the power to revoke trusts. So, our power of attorney and the power of attorneys done by most experienced elder law attorneys have all of these asset protection powers and more. But most power of attorney documents do not have these powers. And so again, you want to make sure you've got not just any old power of attorney, but a good power of attorney done by an experienced elder law attorney. The second document that's part of level one planning is the advanced medical directive. This is what avoids guardianship, because you're naming someone in advance to make medical decisions for you if you're unable to make medical decisions. So there's no need for a guardianship to have someone appointed to make medical decisions for you. The advanced medical directive needs to be HIPAA compliant, of course, which means that doctors can talk to the people that you've named in your document and reveal your confidential financial information. And there's lots of different advanced medical directives out there. And by the way, sometimes you'll hear other terms like living will, which is an old-fashioned term for an advanced medical directive. You'll hear medical power of attorney, you'll hear healthcare surrogate document, lots of different names. But the modern name for these documents is advanced medical directive. The specific name for the one we prepare, that's proprietary to my firm, that I created and have licensed to attorneys all around the country, is the Four Needs Advanced Medical Directive. And we'll look now at what those four needs are. The first need is a medical power of attorney. This is where you name somebody to make medical decisions for you if you are unable to make medical decisions for yourself. This could be anything, consenting to surgery or medical procedures, or terminating medical procedures, or according to your wishes, and anything where you might make a decision. This allows somebody else to make a decision. The second part of this document is, again, proprietary to me and my firm. That's the long-term care directive. This is something that I've created and developed and fine-tuned over the years. It's part of the Advanced Medical Directive. It's also a separate standalone document that is all about helping you get the best long-term care if, God forbid, you find yourself in a situation where you are bedridden, perhaps from a massive stroke, and you can't make decisions for yourself because you can't communicate is often the situation. When you've had a serious stroke, you're paralyzed on half your body. It very frequently, almost always, takes out your ability to speak, or your ability to speak clearly so that people can understand you. And this long-term care directive becomes your voice in that scenario. It tells people who you are as a person and what are your likes and dislikes and preferences and habits. Things like food, dietary preferences, dietary habits, like what types of foods do you like? What types of foods do you hate? Um, do you have certain habits with food or beverages, like starting when you wake up in the morning? Do you drink coffee? And if so, how many cups do you drink, and how do you take your coffee? Or if you're a tea drinker, what of the 1,000 different types of tea, what type do you like? Um, Throughout the day, do you like a hot breakfast? Are you a cereal person? Do you like a hot lunch? Or are you a cold sandwich person? Um, you know, there you may not always get everything exactly the way you want it, but it really helps if people know these things about you, because there often are choices, especially if you're getting in-home care with an in-home caregiver and you have children or other loved ones who have looked at your long-term care directive and given guidance to your caregiver. This is what mom wants, this is what dad wants, because here it's spelled out in their long-term care directive. It gets into daily activities. Okay. If you're bedridden, again, whether at your home or in a nursing home or an assisted living facility, all you can do is sit and passively absorb entertainment. Well, what kind of entertainment? Um, do you prefer movies, TV shows, audiobooks, music? Maybe you like all of them, but maybe you have specific preferences, as most people do, within movie genres, specific types of books. Maybe you're a history buff. Maybe you like science fiction. Maybe you like fantasy. Of with movies, maybe you like certain actors, certain directors. Maybe you prefer audiobooks versus having somebody read to you. I mean, the list goes on and on. Um, as far as daytime activities and the types of things you would enjoy the most. The long-term care directive gets into grooming and hygiene preferences, like what types of soaps and shampoos and lotions and lip moisturizers you prefer, um, deodorants, uh, everything to do with grooming and hygiene. The The long-term care directive gets into sleeping preferences. Do you sleep on your back or on your side? How many pillows do you like? Do you like firm pillows or soft pillows? Do you like multiple pillows? Do you sleep on your side with a pillow between your knees, or do you sleep on your back with a pillow under your knees? There again, there's so many different uh, specifics that people have preferences for, and some of you may be listening to this and thinking this is absurd. Are there really people that high maintenance? Some of you may think that, and others of you are thinking, yeah, he's talking about me, and I know, I want someone to know my preferences. I'm very picky, and if you can make your preferences known, and possibly get the type of care you want, there's no 100% guarantee, but if you have somebody looking out for you, the chances are better than not that they're going to help make sure that your long-term care directive gets followed and that you have a decent quality of life instead of a potentially terrible quality of life in an already terrible scenario where, you're bedridden and can't communicate. Ah, moving on. The third need, that's part of the four needs advanced medical directive, is the near-death directive. This is obviously applies to people with like terminal cancer when they're near death or they have some other illness, maybe late stage dementia where they've stopped eating and they're nearing death. This part of the document is what used to be called the living will, which was used to be when it first came out, like in the late 80s, the living will was a one size fits all document that said, if I have a terminal condition, pull the plug, don't keep me alive. And maybe that's your wishes as part of your near death directive, but maybe it's not. Maybe your wishes are slightly different. Maybe they're very different and you do want to be kept alive at all costs. Most people don't want that, but many people have sort of in between wishes like, well, keep me, if it looks like I'm terminal, keep me alive at least for enough time for my family to all come and gather and say goodbyes before you just discontinue the treatment. That's what a lot of people say. But yours can be customized to exactly how you want it. This whole document is very, very customized to your specific desires. And the last part is the after death directive. This is where you specify whether you want to be an organ donor, whether you want to be cremated or buried, how you want your bodily remains disposed of, whether that's going to be buried somewhere or ashes sprinkled somewhere. You can write your own epitaph. You can write your own obituary. All kinds of stuff that have to do with after death wishes gets put into your after death directive. All right. Another pop quiz. Does a will avoid probate after death? Excuse me. If you're like most people, well, if half of you are like most people, about half of you probably thought the answer to this question was yes, that a will avoids probate. But probably all of you are in the smarter camp, and probably all of you realize that the correct answer is no, that a will does not avoid probate. In fact, a will causes probate. A will is a ticket straight to the probate court. In fact, a will only becomes valid and effective as a will once it has been admitted to probate. Remember, the full name of a will is a last will and testament. You can change your last will and testament 100 times. And whichever the last one is before your death, that's the one that's going to get probated. And once it's probated and acknowledged to be your official will, that starts probate. Why do people want to avoid probate? Well, the pain and confusion and head scratching and the nightmare that we've already talked about. It truly is not something you want your loved ones to have to go through. And again, we have good news. Just like we have level one planning to avoid lifetime probate, we have level two planning to avoid after death probate. So this builds on top of level one planning and includes level one planning, but level two planning adds in a revocable living trust. This is typically done by adults in the midst of life, 25 to 65. And the whole purpose of a revocable living trust is to protect your assets from going through probate after death. The way it does that is that the trust is an entity that you create by signing a document, a trust agreement. It's basically an agreement that you, as the creator of the trust, make with yourself as the trustee of the trust. The trustee manages the trust for the benefit of the beneficiaries of the trust. Well, as long as you're alive, you, and when I say you, it's you and your spouse if you're married, you are the beneficiaries of your own trust. So you're managing the money and your assets for yourselves while you're alive. And nothing changes in your life. It's just a document that uh, is technically an entity that owns your assets, but nothing changes with the way you live your life, pay your bills, file taxes, etc. What changes is that the idea when you have a revocable trust is you retitle your assets into the trust. That means, for instance, with your real estate, we prepare a deed putting your house into the trust. For your other assets, your financial accounts, you go online or you call your investment institutions, or you go to the bank after you've signed your trust and you tell them, hey, I'm setting up a trust, or I've set up a trust and I want to retitle this account into my name as trustee of my trust. Now it's in the trust and you're going to start getting statements in your name as trustee of your trust. And the trust has instructions in it that say, upon my death, here's where the assets go. And those assets can go to whoever you want, just like they could through a will, but they avoid probate because wills go through probate. Now, the trust also avoids multi-state probate. This happens much more often than people realize, and it happens when people own real estate in more than one jurisdiction. I'm sure many of you have your primary home here in the DMV. I'm guessing most of you live here in DC, Maryland, or Virginia, um, where you have your primary home. But if you're like a lot of our clients, you may have a second home in another state. Maybe it's a property that you used to own and you converted it to a rental property. Maybe you purchased a second home and use it as a second home or a rental property. Maybe you inherited uh, a partial interest in a piece of property in another state where that from your parents or grandparents. If you don't put that real estate into a trust or an LLC or some other entity, it's going to go through probate in the state where it's located. So a trust is often used to avoid multi-state probate. Trusts also provide financial privacy. And this has become more important, more and more important these days because of identity theft and all the scammers out there, con artists that target um, seniors, they target widows and widowers. They go through probate records that are public records to see, oh, here's an inventory. This person died and they left a spouse and they've got $2 million. We're going to go start spearfishing and targeting this person. Um, Spearfishing is an email thing where scammers get your financial information and send very targeted threats or scams that look real to try to gain access to your bank accounts. And sadly, this is a multi-billion dollar criminal enterprise in this country and around the world. And some of this is fueled by probate records because of all that financial information being public. With the trust, it's completely private. So it helps a little bit to avoid some of the cons and scams and phishing and identity theft that's so rampant out there. Now, after you die with a revocable trust, and by the way, this applies with an irrevocable trust also, uh, because when you die with a revocable trust, that trust becomes irrevocable immediately upon your death. If you're an individual, if you're a married couple, it becomes irrevocable typically on the death of the second spouse to die. And that's because if you're dead, you can't revoke the trust anymore. So just as a natural consequence of no longer being alive, you can no longer revoke the trust. So it becomes irrevocable. And it can either terminate at that point, which is shown here on the left here and with the red graphics, where your trust terminates, the money goes outright to your children, so they can put it in a safe, but they have no protection from any of life's financial risks because it's just money they now inherited and they own. Or you can have the money go to your children in what we call beneficiary asset protection trusts. These are these go by many different names, including spendthrift trusts, dynasty trusts. That's typically a term used for, people who are very wealthy, but it's the same thing. It's basically a protective self-managed trust, meaning each child can be their own trustee. They can manage the money for themselves. They can spend the money however they want. But if they don't spend it, if they leave it in their locked safe here, protected, the money that they don't spend is protected from everything: lawsuits, divorce, bankruptcy, medical bills, nursing home expenses, any of life's financial risks that may be thrown at your children or your other beneficiaries. Most of the time it's your children. Um, but this can apply to whoever your beneficiaries are: grandchildren, nieces, nephews, friends, whatever. So this is a nice add-on feature to a revocable trust or an irrevocable trust to protect assets for your beneficiaries. All right. Now, what about joint ownership and beneficiary designations? A lot of people ask this question, and a lot of people think that joint ownership and beneficiary designations completely solve the problem of probate, and therefore, why would you need a trust? Well, let me tell you why. First of all, joint ownership is typically only between spouses. And yes, it avoids probate when one spouse dies, but it doesn't avoid probate when the second spouse dies unless you make your children the joint owners of your account, which is generally a terrible idea because if your children, if you make a child the owner of your account, first of all, if you have more than one child and you only name one child as a joint owner, we see this a lot. What you wind up doing is disinheriting your other children and causing a huge family rift. But also, what you're doing when you add one or more children to your accounts is you're exposing your assets to all of their creditors. And, meaning not only the assets exposed to your creditors, but they're exposed to your children's creditors. So if they get sued, if they get go through a divorce, if they have to file bankruptcy or have catastrophic medical bills, all of your accounts get dragged into this mix because you've named your child as a joint owner on your accounts. Um, so joint ownership, not a good idea as a general rule, except between spouses. Now, what about beneficiary designations, which I abbreviate here as BDs? Well, those also are not a good solution for avoiding probate for a lot of reasons. Number one, they don't work for all types of assets. You can't name a beneficiary for everything. They're tedious to change. So let's say you have 10 different accounts at different financial institutions with different beneficiaries named, and all of a sudden you want to change your beneficiaries. Well, you got to now go back to all 10 different institutions and change your beneficiaries. It's hard enough doing it the first time, much less having to go back and do it again with 10 different financial institutions. And worse yet, you probably don't even remember who you named as your beneficiaries. Most people don't keep a record of that. They fill out a form when they set up an account. Nobody gives them a copy of that form, and it's lost to the paperwork of that financial institution. You might be able to request it, and the financial institution will hopefully be able to send you information on who the beneficiaries are. Some places have them online now, which is very helpful. And sometimes you can even change beneficiaries online, which is great. But it's still tedious to change, and they're tedious to keep synchronized. If a lot of people make the really bad mistake of, let's say you have 5 different accounts, and or let's make it 6 accounts. Let's say you have 3 children, you have 6 accounts. So you decide to make each child the beneficiary of 2 accounts. When I say account, it might be a retirement account, it might be a life insurance policy, it might be a brokerage account, could be anything. So, and you try to equalize it by, having the monies in there being roughly the same. Well, that's going to change. Your money changes. You spend money. You might completely spend one account. Maybe you're leaving an IRA to one of your kids thinking they're going to get the full amount. Well, they're not, because they're going to have to pay taxes on 100% of the money you're leaving them. So trying to do estate planning using those kinds of mishmash beneficiary designations is a mess. It's not a comprehensive estate plan. It's a recipe for disaster. Beneficiary designations don't work for minors. Minors cannot own assets, people under 18. And if they wind up owning an asset, they can't do anything with it. They can't spend it. They can't use it. They can't buy anything because they don't have the ability to handle money as a minor. Now, you may be thinking, this doesn't apply to you because maybe all of your children are adults. Well, excuse me, do you have any grandchildren? Is it possible one of your children may die before you, and all of a sudden a grandchild who is a minor becomes a beneficiary? Of course it is. You never know what's going to happen. And this points that out. Beneficiary designations don't work if the named beneficiary dies before you, because what happens to the money at that point? Does it go to their children? If they're a minor, now what? They can't do anything with it. It's going to wind up in probate. Or maybe it doesn't go to their children. Maybe it goes to their spouse. Or maybe it doesn't go to their spouse. Maybe it just disappears and it goes to the other beneficiaries you named. Maybe if you have three children and one dies, maybe the beneficiary designation paperwork says it all goes to the other two children. Do you know? Probably not. Again, because when you signed the form with the financial institution, it had its rules. And most people don't pay a lot of attention to those rules. And those rules may not be what you would want. So money may wind up going somewhere where you don't want it to go, including possibly to probate. Maybe the beneficiary designation says if a beneficiary dies, their before you, their share goes to probate, goes to their state. Well, so much for avoiding probate. Beneficiary designations don't work for disabled beneficiaries because disabled beneficiaries are typically on public benefits like SSI and Medicaid, which require that people have less than $2,000 of assets as a general rule. And if you come along and you die and you leave them money through a beneficiary designation, you've just knocked them off of benefits that they probably worked really hard to get on. Now, you may be thinking that doesn't apply to me. You don't have any disabled beneficiaries. And to that I say, you don't right now, but you might, because you never know when one of your beneficiaries might become disabled. Beneficiary designations also don't work if the beneficiaries are not aware that they're beneficiaries. There is over $100 billion of unclaimed property in our country because of failed beneficiary designations, in part because beneficiaries didn't know they were beneficiaries. A lot of parents are secretive about their assets and don't even tell their kids what the assets are, much less that they're beneficiaries. So, there's a reason there's over $100 billion of unclaimed property in our country. And a huge part of that is beneficiary designations not working. They also don't work if the beneficiaries can't get access to your death certificate, because every beneficiary you name has to get an original death certificate, which are provided by the funeral home, typically to one person. If that one person doesn't choose to share them with other people, you've got a real problem, because now the beneficiaries can't go to the financial institution and fill out the claim form and prove that you're dead. Also, a huge, huge problem. And yes, that's what has to happen. Financial institutions, when you die, they're not going to, on their own, reach out to your beneficiaries and tell them, hey, beneficiary, your loved one just died and you're the beneficiary and here's your money. That is not how it works with any financial institution. It is incumbent upon the beneficiaries to know that they're a beneficiary, to know where your accounts are, to know your account numbers, to get your death certificate, and to make an appointment and fill out the proper paperwork with the proper institution to make a claim. And hopefully, if they do everything right, eventually they'll get their inheritance. So beneficiary designations are not this seamless, magical way to transfer assets upon death that most people are falsely led to believe. So, as you can tell, I'm not a fan of beneficiary designations unless your beneficiary is your trust. And then that's fine, because your trustee is going to have information about all of your assets, and your trustee can easily do the stuff that needs to be done. But typically, you make the trust the owner of your assets. But sometimes the trust will be the beneficiary, like for retirement accounts, where the trust cannot become the owner while you're alive, but you will name the trust as the beneficiary upon your death. All right. Uh, Let me move on here. All right, another pop quiz. Does a revocable living trust protect your assets when you wind up in a nursing home? I'm guessing some of you on this webinar have a revocable living trust, and I'm guessing that some of you are hoping the answer to this question is yes, but it's not. It's a big whopping no. And this is the big limitation of a revocable living trust. It's not a defect, it's just how a revocable living trust works. It's a built-in limitation. There is no protection from creditors with a revocable living trust, including no protection from the biggest and most likely creditor that all of us face in our lifetime, which is the nursing home or assisted living facility or other long-term care expenses like for in-home care. Um, There's just no asset protection from with a revocable living trust. The revocable living trust protects the assets from probate. That's it. The fact that it is revocable means that you can take all the money out. And if you can take all the money out, so can your creditors. They stand in your shoes. That's how the law works. Excuse me. So, why do we care about this? Well, we care about it because of the ridiculously absurd expenses of long-term care and getting more and more expensive every year. I already mentioned nursing homes, earlier I said 14 to 16. It's, really if we go all the way down to Fredericksburg um, area, there's some as low as 12,000 and there's some that are as high as 19,000 a month in the DMV. And actually, it's sometimes more than that, but there are nursing homes that are sometimes 35 to $40,000 a month, particularly if there are unusual medical conditions. Usually, that's involving someone who's on a ventilator. That's where nursing home care is absurdly, well, it's already absurdly expensive, but 35 to 40,000 a month is just, mind-boggling. Even 12 to 19,000 a month is unaffordable for most people for any significant length of time. Assisted living, less expensive, 6 to 12,000 a month in the greater DMV area, including, going all the way down to Fredericksburg, Virginia. Here, more locally in the DMV proper, the range is about 8 to 12,000 a month. And the holy grail of care that most people want, which is to age in place and stay at home and have 24-hour in-home care, that's a wonderful goal, but we're talking $20,000 to $30,000 a month to afford that kind of care. So again, it's doable for some people, but most middle class, upper middle class folks, don't have that kind of money where they can afford to pay for that, at least not for very long. And that's why people are worried about protecting their assets from long-term care expenses, is so that they don't have to go broke. Now, we talk about long-term care expenses. Let's define what I mean by long-term care. Long-term care is care that people receive to help them with activities of daily living. The activities of daily living are bathing, dressing, eating, self-explanatory. Transferring, that's getting out of a bed into a chair or moving from a standing to a sitting position, basically changing position, between lying, sitting, standing. Continence is the ability to remain continent, to not, have accidents of bowel or bladder. Or if you do have occasional accidents, but you're able to clean up after yourself and appropriately and put on new adult undergarments, then you don't need help with that ADL, activity of daily living. Toileting is similar, but uh, toileting is the act of realizing that you need to use the toilet, getting to the bathroom, properly using the toilet, properly cleaning up after yourself, etc. And if you can do all that by yourself, you don't need help with that activity of daily living. But many people, as they age or as a result of a stroke or dementia or other illnesses, they start needing help with these activities of daily living. And typically, when someone needs help with two of these six ADLs, that's considered that they need assisted living. And when someone needs help with four of these six activities of daily living, that's generally considered needing the nursing home level of care. And assisted living can happen in an assisted living facility or at home. And same thing with nursing home care. That can happen in a nursing home or at home. Now, an overlay to all of these physical problems are cognitive impairments, Alzheimer's and any other types of dementia. There's at least half a dozen different types. These can also cause the need for long-term care, from assisted living to nursing home level of care. One of the key factors that somebody with dementia might be experiencing that might require the need for nursing home level of care is if they would not be able to get themselves to safety in an emergency. If there were a fire and they were left alone, would they be able to call 911 or even call a family member? Or would they know to leave their home? These are safety issues that people with dementia often have a problem with. Dementia is one of the biggest risks for needing long-term care. 1 in 9 people over 65 have Alzheimer's, 1 in 3 over 85, most eventually needing nursing home. Strokes, 600,000 people a year. Someone every 45 seconds just in our country has a stroke, one of the main causes of needing nursing home care. Osteoporosis, also osteoarthritis. These are weak bones, brittle bones. People become at high risk for a fall. And when they do fall, they have a greater risk of breaking a bone, and a broken hip or a broken pelvis. If it is inoperable, which it sometimes is because it's a bad shatter, or maybe the person is just not a surgical candidate because they don't do well with general anesthesia, or they're too frail, or they have other medical conditions that make surgery too risky. That can mean they can no longer walk and they wind up bedridden in a nursing home. Parkinson's, another big one. My brother died of Parkinson's and bipolar disorder uh, after living with us for the last 2 years of his life. And one of approximately 1 million Americans a year diagnosed with Parkinson's. And the average age is 60 when someone is diagnosed with Parkinson's. It's striking, but there's lots of foundations, and Michael J. Fox Foundation and others working on finding cures and treatments, but Same with Alzheimer's, but so far nothing really in the pipeline that is going to prevent any of these things. Um, Long-term care expenses are so catastrophic that 70% of individuals become impoverished within a year of going into a nursing home. And it's not just the elderly. A big study by Unum Insurance, which at the time was the largest long-term care insurance company in the country, found that 46% of their long-term care claimants were under 65 at the time of disability. And I can tell you, in our firm, at any given time, we probably have 4 to 6 clients who are under 65, often in their 50s, who are in a nursing home because of all kinds of different things. Uh, we had 2 people in the last couple of years who became quadriplegics from falling off a ladder. We had 2 people who became quadriplegics from body surfing, of all things. I'd never even had heard of that, and we got 2 people in one year with that. So, it's not just the elderly. Um, and long-term care insurance is great if you have it. If you don't have it, I recommend it. I even have an insurance company where I offer it and can help people purchase it. But less than 10% of Americans have any type of long-term care insurance. So that's not the solution for most people. Um, One last thing I want to talk about before our break is, and we're going to take a quick 5-minute break after this slide, is taxes. There's a huge misunderstanding about estate taxes and gift taxes, and inheritance taxes. People get these all mixed up, and people think there's an annual limit on gifting, which there's not. So just to clarify this, there's a federal gift and estate tax exemption, which is just under $14 million per person for this year. Double that for a married couple, $28 million. Now that's scheduled to be cut in half in 2026, but probably won't be, given that this exemption amount was part of a law that was put into place during Trump's first term. And given that he's back in office, it's probably likely that these tax cuts will be extended, or these tax breaks for the super wealthy will be extended. So the good news there for most people is you don't have to worry about ever paying a penny of gift tax or estate tax. And the gift tax, people think there's this annual limit. There's no limit. There's an annual exemption, which this year I think it's gone up to 19,000 a year. All that means is if you give one, if you as one person give one other person more than $19,000 in one year, then you have to file a gift tax return. But it's informational only. You're never going to pay estate tax on that unless you give away a total during your lifetime of $14 million. So even though you may file a gift tax return, unless you've got 14 million or 28 million as a married couple, you're never going to pay gift taxes. And the people who receive a gift from you, they never pay gift taxes. People who receive inheritance don't pay taxes on the money they receive, except in 12 states. 12 states and DC have an inheritance tax. And well, I'm sorry, 12 states and DC have a state level estate tax. So, and there's a smaller limit, like 5 million for DC and Maryland estate taxes. And there's 6 states that have an inheritance tax. Maryland is the only state in the country that has both estate and inheritance tax at the state level. But that inheritance tax doesn't apply to children. It only applies to collateral heirs like nieces and nephews or friends. And that inheritance tax is a tiny, tiny fraction, like 1 or 2%. It's nothing to worry about. Um, so, all right, and that's, yeah, I mentioned the inheritance tax here in the last bullet. All right, so with that, it is we're going to take a 5-minute break and let people stretch their legs, use the restroom, grab a cup of coffee. I will see you back here at in 5 minutes. All right, we are back. So I mentioned 2 slides ago that only about 10% of the public have long-term care insurance. The good news is that for the 90% of you who don't have long-term care insurance, there are still ways to protect your assets from the expenses of probate and, most importantly, long-term care. And for this, you need what we call level 3 planning or level 4 planning, which are both types of asset protection planning, and both of which share the same goals. And the goals of this type of planning are to help people qualify for available benefits as early as possible. And we do that asset protection in order to preserve your dignity and quality of life. So first of all, the benefits we help people get, the main one is Medicaid. There's also a veterans benefit called Veterans Aid and Attendance, which we'll be talking more about. That's for qualified wartime veterans. Um, and when I talk about protecting assets to preserve your dignity and quality of life, what that's all about is that most people doing this type of asset protection are doing it because they are putting money in the hands of a trusted loved one, typically a spouse or a trusted adult child or children. And the hope is that your trusted spouse or your trusted adult child is going to use that money that has been protected to make your life better if you are in a nursing home. So let's say you're in a nursing home, you've done asset protection, you're getting the Medicaid to cover your nursing home care. It's covering the basic room and board. But the money that you've protected can be used by your spouse and your children to make your life better. Also to make the spouse's life better, of course. I mean, they need to live and have money to survive. But the money can be used to make your life better by paying for things that Medicaid doesn't cover, like replacing lost or broken eyeglasses, dentures, hearing aids, things that often go missing in nursing homes. Um, it, Paying for your cell phone bill, paying for streaming music or movie services, um, even hiring a private sitter to be with you 4 to 8 hours a day, maybe longer. Someone to be a companion, someone to help put on a new movie or a new audiobook, or to help you get to the bathroom every couple of hours so that you don't wind up having to sit in dirty diapers for hours each day, as is sadly the fate of many people in nursing homes. who have incontinence issues and pushing the button when you need help getting to the bathroom doesn't always qualify as an emergency because there are a lot of more pressing medical emergencies in a nursing home, and there is, of course, limited staff. You don't have one-on-one care in a nursing home. You have, maybe one caregiver to every seven, eight, nine residents of a nursing home. So having these assets that have been protected to make your life better, that's the main goal of asset protection for most of our clients. Now, some people have other goals. As I mentioned, the spouse is a big one. If you are married, of course, you want to protect your income and your assets for your healthy spouse. If you're happily married, you don't want your spouse having to downsize their home or move in with a child or live in some one bedroom or studio apartment, or worse, wind up homeless because all the money is going to pay privately for your care. A lot of our clients want to protect their family home. Family home for a lot of people is their main asset. Maybe they weren't able to save during their life other than to buy their home. Or maybe they've spent all their money paying privately for care, and all that's left is their home, and they're coming to us to protect their home. And maybe they're protecting it for the spouse, or maybe it's for their children or sibling that might be living in the house. And these days, more and more, we see children living with parents, adult children. And sometimes that's kids that never moved out, the so-called failure to launch kids. There's the boomerang children who come back after college or after a divorce, and come back to live with mom and dad. And then there's the wonderful caregiver child who maybe quits their job and moves in with mom and dad to take care of mom and dad so that they don't have to move to an assisted living facility or a nursing home. No matter how it starts, it's typically going to wind up with the child helping the parent stay at home, helping them avoid needing to move into a facility of some sort. And we have a lot of clients in that scenario who want to protect the home for their children so that their children have a roof over their head. Sometimes it's a disabled child. I met with someone earlier this week with and this happens probably once or twice a month. A parent who has a child living with them who is disabled in some way, mental illness, physical disabilities, and they would just not be able to put a roof over their own heads if it weren't for the parent and them living with the parent. And of course, the parent wants to protect the house for that disabled child. Very important to understand that the type of asset protection we do under level 3 planning and level 4 planning is completely legal, completely ethical. We absolutely do not hide assets. Hide is literally a dirty 4-letter word. Okay. Hide implies you're stuffing money in a mattress and not reporting it. We never would uh, have a family member do that. And if we found out that a client was doing that, we would dismiss that client immediately. That is simply not allowed. That is fraud. So we do not hide assets, but thankfully there are dozens of legal and ethical strategies where we can protect or shelter your assets. It's just that these strategies are not very well known because this is the most complex area of the law. But conceptually, it's just like income tax planning. What does everybody do um, at tax time? Well, if you're like 99% of the country, you are trying to maximize your deductions and your legitimate credits in order to get back the biggest tax refund you're entitled to get. If you use all the available credits and deductions and tax saving strategies that you're allowed to use in order to get back a big tax refund, are you ripping off the government? Of course not. You're just doing good tax planning. You know, now, are there people who cheat on their taxes and commit tax fraud? Absolutely. And those people often get caught and often go to jail for tax fraud, as they should. But of course, we're not talking about that. We're talking about all of you folks who I'm sure are honest tax-paying citizens, but nobody wants to pay more tax than they have to. And if you can get back a tax refund, of course you want to get a tax refund. Well, Medicaid planning, it's the same thing. Those are tax dollars. Who do you think funds Medicaid? You do. Your family does. Every year that you pay taxes to the federal government and the state government, a huge percentage of your taxes goes to fund Medicaid. In fact, at the federal level, Medicaid and military spending are the top two biggest line items. Um, Education was number three. That may be going away with Trump's latest discussions about possibly doing away with Department of Education. We'll see what happens with that. And at the state level, the two biggest spending items on line items in the state budget for every state are Medicaid and education. So a huge percentage, perhaps half of your tax dollars go to fund Medicaid. And if you're smart enough to do good legal and financial planning so that you can get some of those tax dollars back in the form of Medicaid benefits to help you or your loved one, it's a no-brainer, just like good income tax planning. This type of planning is also necessary to level the playing field, to overcome our country's discriminatory health insurance system. How is our insurance system discriminatory? Well, let me give you a very simple example that everybody understands. Let's look at John and Joe. They're friends, they're neighbors. John has a brain tumor. It's cancer. Joe, the neighbor, has Alzheimer's. What's that? Well, it's plaques and tangles in the brain. If you didn't realize that that's what Alzheimer's is, it is. It's a bunch of stuff in the brain that's not supposed to be there. Just like a tumor that's cancerous is a mass of stuff in the brain that's not supposed to be there. They sound pretty similar, don't they? Same basic underlying disease cause, something in the brain that's not supposed to be there. But the result of what happens to these two families is 180 degrees different. John, because he has a cancerous brain tumor, he gets all of his treatment covered by health insurance. Chemotherapy, radiation, surgery could cost over $1 million. Health insurance is going to gladly cover all of that. I mean, I say all of it. Of course, there's going to be co-pays depending on his insurance. He might have co-pays. He might have some deductibles. Um, But he might not. Some people have really good insurance with no copays and no deductibles, and they pay nothing for their health care, especially veterans who have Medicare and TRICARE for life. They typically pay nothing. And even if they have to pay a little bit of copays and deductibles out of pocket, John and his family are not going to go broke paying for his treatment for brain cancer. And if his cancer spreads or comes back in another part of the brain and he needs treatment all over again, his health insurance is going to pay another $1 million gladly without blinking an eye for all those treatments all over again. Even if it only gives John another 6 months to live, health insurance will pay as much as they need to for all of those health treatments. But and what are those health treatments? That's the care John needs because of the mass in his brain that's not supposed to be there. But let's look at his poor neighbor Joe and his family. He's got the plaques and tangles in his brain that aren't supposed to be there. Well, there's a couple medications that might make his symptoms slow down a little bit, but there's no cure. There's no surgery, there's no radiation, there's no nothing that targets these plaques and tangles. The care that Joe is going to need because of the stuff in his brain that's not supposed to be there is help with activities of daily living, bathing, dressing, toileting, etc. And he's eventually going to wind up in a nursing home. And the health insurance system is going to snub its nose at him and say, sorry, Joe, that is not covered by health insurance. Unless you have long-term care insurance, which he's probably one of the 90% of people who doesn't, then sorry, Joe, you have to pay privately for your long-term care, the care you need as a result of the stuff in your brain that's not supposed to be there. You've got to pay privately until you go broke, and your spouse has to go broke. And if you live in Virginia, they can go after your children, and your children can be forced to pay for your care. That's called filial responsibility. We don't have that in DC and Maryland, luckily, but if you're in Virginia, that exists. And Virginia is one of about 35 states that has filial responsibility, where children can be forced to pay for their parents' medical bills or long-term care bills in this case, because long-term care is not medical. That's the problem. That's why our system is fundamentally unfair. John and Joe have basically the same thing, a mass of stuff in their brain that's causing a disease. It's causing a series of symptoms. But John's symptoms and treatment get covered by health insurance and Joe's don't, and he's got to go broke. How is that fair? It's not. It's simply not. It's a built-in discriminatory health insurance system. And by the way, this is not the state of health insurance in many developed countries. Do many developed countries pay higher taxes for universal health insurance? Absolutely. And do some of those countries include long-term care as part of universal health insurance? Absolutely, because it's all part of the same healthcare spectrum, but not in our country, and it probably never will be in our country because it's too much of a political hot potato. So if you have any qualms about the ethics or legality of this type of planning, hopefully this explanation of our discriminatory health insurance system will get you over that very quickly, and you can share that with your friends and family members who may think that there's something wrong with doing completely legal and ethical Medicaid planning, which is, of course, total nonsense. It's just that this type of planning that we're talking about today is very poorly understood because as I mentioned at the beginning, I'm only one of about 570 certified elder law attorneys in the entire country. And that's because Medicaid is the most complex area of law in existence. And here's the US Supreme Court saying what I just said, which is that in the one case, Medicaid case that went to the Supreme Court called the Medicaid laws an aggravated assault on the English language, resistant to attempts to understand it. This is back in the 80s, I think, a very different Supreme Court than the one we have today. Um, the these are the brightest legal minds in the country, Supreme Court justices. This is what they had to say about Medicaid. And another great case from one of the Circuit Court of Appeals right under the Supreme Court. In fact, this was the Fourth Circuit Court of Appeals, which covers Virginia. And in fact, this was a Virginia federal case that went to the Fourth Circuit Court of Appeals, which called the Medicaid Act one of the most completely impenetrable texts within human experience and dense reading of the most tortuous kind. This gives you an idea why there are only 570 of us certified elder law attorneys in the whole country. And just the process of becoming certified, it's, of course, after law school, you've got to go through at least another 5 years of practicing elder law. You've got to get referrals from other elder law attorneys who are familiar with your work and know, that you are an expert in the field. And you have to pass a full day specialty elder law bar exam, which has on average a 20 to 30% pass rate. Again, just, this is because of the complexity. It's a lot of what being a certified elder law attorney is about, is understanding Medicaid. Now, I've talked a lot about Medicaid. Let me be clear that if it hasn't been clear already, that the type of Medicaid I'm talking about today is long-term care Medicaid. All right. Very different from health insurance Medicaid. And this is critical to understand because if you try to do any research on your own about Medicaid laws, you're going to find all kinds of erroneous and contradictory information. And 95% of the information you're going to find is going to have to do with health insurance Medicaid. But they're not going to call it that. They're just going to call it Medicaid. The popular media does not understand that these are two completely different programs. Health insurance Medicaid and long-term care Medicaid are apples and oranges. I mean, yes, they're both types of Medicaid, but they're completely different programs, completely different rules to qualify for these programs. Health insurance Medicaid is for poor people. That's welfare for people with very low income. Long-term care Medicaid is not at all welfare. It's not for low income. In fact, it's often called middle class Medicaid. And we'll talk about the income requirement in a minute. It's not what you think. First of all, long-term care Medicaid is the type of Medicaid, of course, that pays for nursing home care, as we have been talking about for this webinar. Medicaid also pays for in-home care in most states through a waiver program. Not in every state, but in most. In Virginia, Medicaid will pay for up to 8 hours a day, 7 days a week of in-home care, assuming somebody needs the nursing home level of care. That's critical. DC is even is twice as good. DC will pay for up to 16 hours a day, also 7 days a week of in-home care. We have some clients who move from Virginia or Maryland into DC, rent an apartment specifically to get DC's in-home Medicaid. And Maryland, unfortunately, there's basically no in-home Medicaid program. There is a program that theoretically exists, but it's got like a 15-year waiting list. And so it's basically a non-existent program, and you cannot rely on it. And it is almost impossible to ever get somebody on in-home Medicaid in Maryland. Very, very sad. There's also a type of Medicaid called PACE, which is a program for all-inclusive care for the elderly that combines Medicaid with Medicare. It's usually available through a daycare facility. It's not in every location, but they're in some areas. There's one in Northern Virginia called Cherry Blossom Pace, which the daycare center is in um, Annandale, Falls Church area. Um, Covers almost all of Northern Virginia. They pick people up in a van in the morning and bring them there, and they arrange for all their medical care as well as their long-term care. There's some locations throughout Maryland that are run through Hopkins. There is not yet a PACE program in DC. They are theoretically working on it, but they have been theoretically working on that for many years and nothing has happened. So we'll see. So, how do people get long-term care Medicaid? Very easy. You have to simply meet the eligibility criteria, and there's basically four criteria. You have to be medically in need of the nursing home level of care, which we talked about earlier, typically needing help with 4 activities of daily living or more, or having a pretty significant cognitive impairment where you can't handle yourself in an emergency, you can't get yourself to safety. The income requirement, again, this is middle class Medicaid. It's not for low income people. Your income just needs to be lower than the cost of care. Remember, nursing homes in the DMV are 12 to 16,000 a month. That means you could have really high income of say $10,000 a month as an individual, and you can still get Medicaid because you don't have enough income to pay privately for the nursing home. So the general rule for a single person, not married, uh, widower, never married, is that your income goes to the nursing home. Medicaid pays the difference. Okay. So your income becomes your copay. Now they let you keep a little bit of your income, depending whether you're in a nursing home or at home. You get to keep a lot more if you're at home than you do if you're in a nursing home, because they recognize you have costs for living at home, like rent or mortgage or, and utilities and food and whatnot. But again, this is not a low income program. We have clients with very high income who are on Medicaid. The other big factor is the 5-year look back period. So if you have made a gift within 5 years of applying for Medicaid, Medicaid is going to add up all of those gifts, divide that by a number that's different in each state. It's called the penalty divisor. And the result of that division problem is that it's going to be a period of months of ineligibility for Medicaid, which can be longer than 5 years. So, for instance, the average penalty divisor in the DMV area is about $10,000 a month. Um, so just to understand how this concept works, if you were to, let's say, put $1 million worth of assets into an irrevocable Medicaid asset protection trust, which we'll be talking about in a few minutes. And if you were to apply for Medicaid, uh, let's say 57 months after you put the money into the trust, okay, less than 5 years. You didn't wait 60 months. You applied after 57 months. Well, you're going to have to report that you gave $1 million away to this irrevocable trust. And because you made the mistake of applying 3 or 4 months early, instead of waiting till month 61, you're going to get hit with a penalty period of 100 months. Divide a million by 10,000. That's 100 months. That's what? Over 9 years. So you're going to be disqualified from getting Medicaid for another 9 years, starting from when you applied, which was 57 months after you funded the trust. So, of course, I'm giving you a scenario that would never happen. Nobody would ever do that, but I'm just explaining that to illustrate how these concepts work. In reality, if somebody put $1 million into one of these trusts, you're not gonna apply for Medicaid until you're past the 60-month look back period. And then when Medicaid asks on the application, have you given away any assets in the last 60 months? The answer is no. So you get immediately qualified, assuming you meet all the other requirements. And then the last requirement for Medicaid, and this is the biggest area where we elder law attorneys come in, is we help you get your countable assets below the asset threshold. And you can see the different amounts, for the three local jurisdictions. That Virginia follows the general rule that's followed by the vast majority of states, which is you can't have more than $2,000 of countable assets. And a huge part of what we elder law attorneys do is convert countable assets into non-countable or exempt assets. And that's how we get people on Medicaid. All right, let's talk a little bit about this Veterans Aid and Attendance benefit. For any of you who served, first of all, thank you for your service. And the government also thanks you for your service by saying that if you need aid and attendance, which you can interpret as meaning assisted living, help with 2 activities of daily living or more, you can apply to get tax-free income from the VA. And here's the amounts. For a single veteran, about a little over 28,000 a year. Married veteran, closer to 34,000 a year, and a surviving spouse a little over 18,000 a year. Tax-free income. Service requirements are minimal. You just have to have served 90 days active duty with at least 1 day during wartime. And you can't have had a dishonorable discharge. And there are financial criteria. Of course, the medical criteria I mentioned, you need assisted living. The financial criteria is very similar to Medicaid, and they look at your IVAP, your income for VA purposes, which is your income minus the unreimbursed cost of your care. So assuming you don't have long-term care insurance, let's say you've got $7,000 a month, but you're in an assisted living facility that costs $8,000 a month. Well, your income is negative 1,000, which of course is zero for VA purposes. So you're going to qualify for this full benefit. And there's a net worth requirement. It's changes every year. All these numbers change every year. Right now, it's about $160,000 that you can have, and as far as assets, and still get this veterans benefit. All right, now let's talk about level 3 planning specifics. This is the Living Trust Plus. This is my trademarked version of a Medicaid asset protection trust that I license to attorneys all around the country. But I don't call it a Medicaid asset protection trust because it does much more than just protect assets in connection with Medicaid. It protects your assets from probate, plus lawsuits, plus veterans aid and attendance benefits if you're a qualified veteran, plus Medicaid. So you see all the pluses there. That's why I call it the Living Trust Plus, which I think is much more descriptive than the term Medicaid Asset Protection Trust. And the last plus is you can stay in control of the trust as the trustee, meaning you can manage all the money yourself, just like you do now. Here's how the trust works. We start in the top left corner. You've got your house, you've got your assets unprotected. We create the trust represented by this rectangle. This is one version. This is the most common version we use. Now you see this one-way sign. This is the most important graphic on this page, is this little one-way arrow, because once you put the money into that trust, or the house into the trust, it's got chains around it. It's protected, but you can't take it out. The assets, once they're in the trust, they're protected immediately from probate, plus lawsuits, plus protected 3 years for veterans benefits if we use the veterans version, plus it's protected after 5 years for Medicaid, plus you can change the trustees and the beneficiaries, and you can be the trustee for most versions of this trust. You're still going to live in your house. You're going to have full use of the real estate. Retirement accounts can't go in the trust. That's federal law. So IRAs, 401ks, TSPs stay out of the trust. Your retirement income and your checking account stay outside of the trust. So you're still going to receive your Social Security, your government pension, your military pension, whatever pension you have, if you have one, into your checking account in your name, which you are going to use to pay your bills just like you do now. So nothing changes with your day-to-day life. And as I said earlier, that one-way sign is crucial. That once you put money in the trust, you cannot take it out. The trustee cannot use money in the trust to pay your bills directly. The only way money can come out of this trust is through what we call a backdoor distribution, which means at any time the trustee can make a distribution to a trust beneficiary. The trust beneficiaries are typically your adult children, your trusted adult children. If a distribution is made from the trust to one or more of your trusted adult children, that money belongs to them. It's theirs, period, end of story. But they can do whatever they want with their money, just like they could right now, which means they could give that money to you, or they could use it for your benefit, just like some children help their parents out every day by paying for their parents' bills. There are no tax repercussions of this trust. For most versions of this trust, the income is taxed to you, the settlor. You're still going to get your $250,000 capital gains exclusion if you sell your home after living in it for 2 out of the past 5 years. Your kids are still going to get a step up in basis upon your death if you still own or the trust still owns the house upon your death. So it's tax neutral. And remember, we talked about gift taxes earlier. When the money if money is distributed from this trust to a child, whether during your life or after your death, the child does not pay taxes on that money. That's a gift. It is not taxable to the child. Gifts are never taxable to the recipient of a gift. This is a slightly different version. I mentioned there's three versions. The difference here is this is the income retention trust. This is mostly for people who have rental income that they live on. With this trust, you are going to receive all of the interest and dividends and rent from the trust. And the third version is a veterans version where it's actually two trusts. There's one for the house, there's one for the money, and the money trust works a little bit differently in that the income, if there is any income, meaning interest or dividends or capital gains on the money trust, that's going to be taxed to your children instead of taxed to you. But you're still going to get the $250,000 capital gains exclusion on the house and the step up in basis on the house if the house doesn't get sold before your death. All right, so just a quick summary for all three versions of the trust. There's no change to your checking account. There's no change to your retirement income. You always keep the right to live in your home. You may retain the right to receive income. And you're always going to get immediate protection from probate, plus lawsuits, plus protection after 3 years for aid and attendance if you're a veteran and you use the veterans version, plus always protection after 5 years for Medicaid, and you remain in control. Except for that money trust on the veterans side, which you can't be the trustee of. All the other trusts, you can be the trustee, you can change the trustee, and you can change the beneficiaries. Even though this is an irrevocable trust, irrevocable does not mean unchangeable. It just means you cannot unilaterally revoke the trust and take the money out. There's nothing in the word irrevocable that means unchangeable. And if you do research on this, you're going to find 90% of the information on the internet is completely wrong on this. You're going to find hundreds, if not thousands or millions of websites saying that irrevocable means unchangeable. And that's simply a lie. That has never been the case with irrevocable trusts. It's a complete misunderstanding of what irrevocable means. It just means you can't revoke it. Just what it says. It does not mean you can't change it. You can change almost everything about this trust. And you can possibly have indirect access to the principal, possibly through a trusted adult child who can receive money. And if they so desire, out of the goodness of their heart, they can use that money for your benefit. But they are never under any obligation to do so. And you can never have any sort of agreement with them in advance that they will do so, because that would be collusion, which would potentially nullify the protection of this trust. How much can be protected with this trust? Well, potentially all of your assets, if you put all of your assets into it. A lot of people don't put all of their assets in the trust. Most people have some sort of retirement account they're going to keep out of the trust. You may keep other assets out of the trust just to pay your everyday bills if you don't have sufficient income to cover your known expenses. But another big question I get every day is, looking at just Medicaid, let's ignore the veterans benefit for a moment. What happens if you need nursing home care before the 5 years is up? Are you totally out of luck? Do you have to make it 5 years without needing nursing home care? No, absolutely not. We can still protect significant amounts of assets. Just depends on the specific facts, how long it is before you need care, how much money you had, how much income you have. Let's look at an actual example of a case like this. So Joan came to me when she was 72 and healthy to do this Living Trust Plus. We did the trust for her. She had $800,000 of assets, 400,000 in her home, 300,000 in a brokerage account, and 100,000 in an IRA. She kept the IRA out of the trust. She also had Social Security income of $20,000 per year. She was 72 and healthy. We hoped that she wouldn't need nursing home care for 5 years, but she had a massive stroke 3 years later. She wound up in a nursing home for the rest of her life. And at the time when she first went in, it was $10,000 a month. Now what? Well, the kids came to us for at first panic because she didn't make the 5 years. Oh my God, what are we going to do? Is it all hope lost? No, all hope is not lost. We simply need to figure out, in her case, how we were going to pay for the nursing home privately for 2 years, because then we'd be past the 5 year look back and can apply for Medicaid. And in her case, it turned out that was easy. For the first year, we liquidated her $100,000 IRA and used that along with her $20,000 Social Security income to pay the $120,000 nursing home bill for year one. And by the way, she got to take a medical expense deduction because all of her income was going to the nursing home, which is a medical expense. That medical expense deduction meant that she didn't have to pay any taxes on the IRA distribution. So that entire $100,000 IRA was able to go to the nursing home to cover her nursing home bill plus her 20,000 of income. What about the second year? Again, simple. One of the sons was the trustee of the trust at that point. He had the money manager of the brokerage account liquidate $100,000 of assets in the brokerage account. And as trustee, he made a backdoor distribution to himself and his brother. And the two of them could have just kept that money, but they were good and loving children, and they decided to use that money to pay the second year of their mom's nursing home care, plus her 20,000 annual income. Boom, second year of the nursing home covered. What was left in the trust at that point? The house worth 400,000, 200,000 remaining in the brokerage account. So there was $600,000 left out of the original 800,000. And that was now protected. So 600 out of 800, that's 6/8, 3/4, 75%. So we protected 75% of her assets, even though she only made it 3 years before needing nursing home care. A very good result. And again, the type of thing that can and does happen regularly. So as great as the Living Trust Plus is, it is simply one asset protection tool, and it's not right for everyone. And it doesn't always eliminate all long-term care costs because it doesn't pay for assisted living. First of all, this trust may not be right for you if you don't have a trusted adult child. It doesn't have to be a child, it could be a friend or significant other or trusted niece or nephew, grandchild. But maybe you don't have anyone like that in your life who you trust. It's not going to work. for you. It doesn't make sense. There's no tool that's right for everybody. This Living Trust Plus may not be right for you if you've got, $1 million or more in an IRA or another tax qualified retirement account, and you don't want to liquidate those funds and incur the income taxes to protect the after tax funds. Although sometimes doing that makes sense. And in some states, you don't have to worry about protecting IRAs because in some states, IRAs are exempt automatically. And again, the Living Trust Plus protects assets in connection with Medicaid, which doesn't cover assisted living, whether that's in an assisted living facility or at home. And that's where long-term care insurance comes in. And again, I have an insurance agency where I can help people purchase long-term care insurance when it's appropriate. And for some people, it's very appropriate. And if you have a policy, great, you should probably keep it. I get asked that every day, and I'm happy to review what you have if you do have it. In addition to the insurance agency that I have, I'm also part of a financial planning group where we do financial and retirement planning for clients. Because all of this financial planning, retirement planning, insurance planning, it's all connected with elder law and how best to pay for long-term care. And so for people who do level 2 planning, which provides no asset protection, it's really important to do financial planning and retirement planning. And even for people who do the level 3 planning, this type of, long-term care financial planning is important because the level 3 planning is mainly for Medicaid, unless you're a veteran. But even then, the veterans benefit is very limited. And, so all of this, we do this specialized type of financial and insurance planning in large part to help people pay for long-term care. Anyway, I do this through a separate company from the law firm. It's called Protection Point Advisors. We help with everything in the financial world. And now to finish up, if you have a loved one who's already receiving or nearing the need for long-term care, that's where level 4 planning comes in. This is also called life care planning. This is about assisting families through navigating what we call the elder care journey, which is not just about protecting assets, but also about getting the best possible care. It usually does include Medicaid and or veterans asset protection planning. This can be done pre-crisis, like right after someone is diagnosed with dementia. We do that frequently. It can also be done during a crisis when long-term care and even nursing home care is already needed or is imminent. And the goal with level 4 planning is to protect as much of the assets as possible as quickly as possible. Usually we're not waiting 5 years. I mean, sometimes if it's a single person and they have a lot of assets, we might have to wait 5 years. But with a married couple, no matter how much they have, with level 4 planning, we can protect 100% of the couple's assets and get Medicaid. The assets are protected for the healthy spouse. We get the nursing home spouse or the Medicaid spouse on Medicaid. Yes, we can protect 100%, even, when the person is already in the nursing home. It's never too late to do this type of planning. In fact, we do this type of planning every day for people. This is one of the most important things you can understand in this webinar is level 4 planning for a married couple. We can protect 100% of the assets and get someone on Medicaid. And this, we're talking 4 to 6 months. We're not waiting 5 years. For a single person, depending on how much money they've got, we can usually protect 40 to 70% of their assets. Sometimes we can protect all of their assets, but always in the neighborhood of 40 to 70%. So just a quick recap. Level one planning is the incapacity planning. That's the power of attorney and the advanced medical directive to avoid lifetime probate. Level two adds the revocable living trust to avoid after death probate. Level three switches the revocable living trust with an irrevocable living trust plus to protect your assets from probate plus lawsuits, plus Medicaid, plus veterans benefits if you're a wartime veteran. And then the level four planning is the life care planning to help you navigate the elder care journey, get the best possible care, and yes, protect as much assets as possible, as quickly as possible, including protecting 100% of the assets for a married couple. Why doesn't everybody do this? Well, a lot of people make a lot of excuses. They think their estate's too small. They have too many choices, which includes, which do you do a will? Do you do a trust? Now, I've introduced a different type of trust, so I've given you another choice. Um, but this is why you need to go to a lawyer who understands all the choices and can help you make the right choice. Don't let too many choices be uh, something that stymies you from doing something. The Medicare myth. A lot of people think Medicare is going to pay for their nursing home. It doesn't. Medicare is health insurance. Remember the example of John with cancer and Joe with Alzheimer's. Well, Medicare is health insurance that will pay for all the cancer treatment, but it's not going to pay a penny for any type of long-term care. The quality of care myth, that's a big one. A lot of people think that, there's only a few nursing homes out there that take Medicaid and they're terrible. Total nonsense. Roughly 96% of all nursing homes take Medicaid, including almost all of the 4 and 5 star nursing homes out there. It's just a financial reality. People in nursing homes run out of money, and nursing homes can't just put people out on the street because it's an unsafe discharge. So they have to keep them. And guess what? They want to get paid something. So even though they get paid less by Medicaid, they still get paid enough to make a profit, which is why almost every nursing home takes Medicaid. And the quality of care you get if you're in a nursing home on Medicaid is the same quality you would get if you're paying privately. The people delivering the care, they don't know who's on Medicaid and who's paying privately or who has long-term care insurance or what. They're just providing care. There are different quality nursing homes, of course. They're rated by the federal government on a 5 star scale, and there's 4 and 5 star nursing homes, and there's 1 and 2 star nursing homes. So that makes a difference. But whether they take Medicaid or whether you're on Medicaid makes no difference in the quality of care you get. And then denial. That's the biggest excuse. People say, I'm never going to go to a nursing home. The plan of a lot of people is, oh, I've told my son to take me out back and shoot me if I ever have to go in a nursing home. And obviously not a good plan because your son would wind up in prison most likely if he actually did that. And I'm preaching to the choir because you folks have tuned in to today's 2 hour webinar because you're the folks who are not in denial. You realize that this is a realistic concern, and that's why you've devoted 2 hours of your time to learn about these issues. So I applaud you for being proactive in that regard. I encourage you to take the next step to create your own plan, which is to come see me. Call the office, schedule an introductory meeting in person or by Zoom. If need to, we can do it by phone. But obviously, all of you know how to use Zoom because you're using it right now by tuning into this webinar. So uh, hopefully, I will get to meet all of you at some point. We do have an intake form that's required. When you call the office to make an appointment, they'll send that to you or send you a link to it on our website. We, as I mentioned, I'm licensed. The other attorneys in our firm are licensed in Virginia, Maryland, and DC. So either you or the loved one that you're wanting to plan for has to live in the DMV. I mentioned if you go to our website, you can sign up for free books in our newsletter. And with that, I will thank you very much for attending. I will put our contact information on the screen and let me turn on the camera here and I will take some questions.